I suppose something that will come up a little later on is that Luigi has written a book. His first book was called Gene Cartels, Biotech Patents in the Age of Free Trade. It was published in 2009 and as a paperback in 2010. He's been critically acclaimed by leading economists, patent law experts from around the world. In 2008, he helped Cancer Council of Australia through his pro bono advocacy to spearhead a campaign against gene patents, leading to an Australian Senate inquiry into gene patents. Having completed his 3-year postdoc ARC-funded research on IP and Aboriginal traditional knowledge with Professor Drahos in 2010, he's returned to his intellectual property consultancy after spending quite a lot of time outside of Australia, both in litigation teams in the US, UK and Europe, including the European Patent Office. So thank you for coming along tonight, Luigi.
Before I start, I just want to say thanks to Lance and Beatrice for inviting me to be here. And the second thing I want to just make very clear is I'm not someone who promotes the patent system. I'm actually someone who's been spent the last 20 years, mostly with my own money, trying to bring some sense and balance into the patent system, and it's getting increasingly more difficult to do that. Right now we have a bill before the Federal Parliament called the Patent Amendment Human Genes and Biological Materials Act. It has been before the Legal and Constitutional Law Committee since for now 4 or 5 months, and this present Labor government is doing its level best to have this law buried and never ever passed. And I want you to understand that this is an issue that is of vital importance. The very last day of the committee hearing on August the 29th, CropLife turned up at the Senate committee and did everything they best to throw mud at this bill. This bill simply seeks to do one thing: to prevent the patenting of genes and other naturally occurring biological materials. That's all it seeks to do, and yet it is being opposed by every biotechnology company in this country, by BioUSA, by the American Intellectual Property Law Association, by the Intellectual Property Law Association of Australia, by the Patent Attorney Institute of Australia, by the Australian Academy of Science, and, you might like to know, by Professor Ian Fraser. So, virtually every major organisation and scientific body in this country, along with all of the 8 major Australian universities and a number of subsidiary universities, have all filed submissions against this bill. Who is putting this bill up? Bill Heffernan, Rachel Seward, Nick Xenophon, right? And it doesn't stop there, and Helen Coonan. And in the lower house, it's Peter Dutton and Rob Oakeshott. Not one Labor MP has put their name on this bill. Not one. And the Minister for Industry, Innovation, Science and Research, Kim Carr, is doing his level best to destroy this bill with the aid of his department and the Australian Patent Office. Now, please let this register. If you want to do anything as a result of what you saw tonight, the first thing you will do tomorrow is ring or write to your local MP and say, why are you not supporting this bill? Because if you don't, this bill is over. And a lot of what you saw tonight is going to happen. So if you really want to do something right here and now, today, tomorrow, go and get in touch with your MP and make a lot of noise. Now, what's the patent system about? It's about what you heard, carburettors. Sorry. It's the Patent Amendment, Human Genes and Biological Materials, Bill 2010. Why have we got this, this sort of diverse group of MPs like Bill Heffernan? Well, Bill Heffernan hates Monsanto for a start, and he's very pro-farmer. Okay? And Rachel Seward. Rachel has been a champion of this. It has brought people from all sides of the spectrum together, except for the Labor Party. Where are they? Okay? So really, you've got to get this message across to the Labor MPs that you mean business. If they don't vote for this bill, you are not going to vote for them. This is really critically important. Australia, this is the first bill in the, what you would call the developed countries that Australia is one of, that is going to actually try and pass legislation of this kind. The first. And what has it done? Well, the US government just, in October last year, filed a submission in the Federal Circuit actually saying, admitting for the first time, that the patent office, the US patent office for 30 years got it wrong when it said you could patent this stuff. It's actually forced the American government to reconsider the Diamond and Chakrabarty case, the case that you heard of on the film tonight. Okay? So this is really major stuff. Australia is at the leading edge of this. You can make a difference. Please do that. Okay, so what's the patent system about? The patent system is about inventions. That's it. So if you invent something, you get a patent for it for 20 years. 20 years now. It's not about, creating intellectual property monopolies over discoveries or minor variations to things that occur in nature. And why are these companies wanting patents? Because control. It gives them legal control. It's not ownership. Please don't make the mistake that a patent gives people ownership. It doesn't. It gives them control, which is even better. And it gives them legal control. As you could see, with that sort of control, people like Percy Smicer can be put out of business if they wanted to. It gives them enormous power. And why did this all happen? Because why are we talking about this? Why is this bill so important? Why are we talking about it in the context of food? Well, it happened because in 2008, an American company which had a patent over the BRCA1 human gene, which is linked to breast and ovarian cancer, through its Australian licensee called Genetic Technologies, actually tried to close down all breast and ovarian cancer gene testing in this country using that patent. And that's why I got involved. I rang up the Cancer Council and said, right, do you want to fight this? Because if you do, you've got me. And they said, yeah, let's fight it. So that's how this is all starting to happen, but there's a convergence. Genes are genes, whether they're plant, human, animal, it doesn't matter. The same issue is there to be dealt with through this bill. Sorry for taking a long time, but I had to get that out.
Patent laws are different in every country. What are the requirements for granting of a patent in Australia? And where does it stand over biological matter that already exists in nature and seeds?
Well, this is the great spin. You'll be told that patent laws are the same all the world over. Well, they're not. They vary from country to country, and they're interpreted differently from country to country. I mean, within Europe, the same patent issued by the European Patent Office will be dealt with differently depending on which country and which courts deal with it. And that's the truth. A patent that will be upheld in one country will not be upheld in another, and so forth and so forth. And then the claim language of a patent is very critical, because the claim language is like the boundaries of title, and they vary depending on which examiner examined the patent, what obstacles were put in front of the patent applicant, etc., etc. In Australia, we have, unfortunately, a patent office that is in the business of rubber stamping patents. Do you know what the average time that a patent examiner spends on a patent? Less than 20 hours. Do you know how long some of these biotechnology patents are? In excess of 500 pages. Do you think that these poor people, because these examiners, it's not their fault. I mean, they're basically locked away in an office in Woden in Canberra, and they're given every day a pile of patents, and they're told, you have to go through these patents every day because we've got 70,000 patents backlogged and we're getting complaints we're not processing these things fast enough. So what happens? These poor guys and girls sitting in this office sit there and go, oh, okay, we'll let this one go, we'll let this one go. And what's been happening is that patents have been granted with a minimum of perusal, minimum. And it's just creating a network of monopolies all over the landscape.
On the topic of climate change, just rattle you a little.
Okay.
Are there plant genes with climate change applications? Are patents being granted over such genes? In this case, in Australia as well? And if so, how would this practice impact on agriculture in the future?
The answer is yes to all of those. And what's being patented isn't just the plant; it's the actual the gene, the genetic traits for creating a plant that might be more likely to resist drought or be able to grow in harsh environments, sort of high salt environments, etc., etc. So the patent claims are actually over these genetic traits. I mean, the question that comes to me as a patent attorney or a patent lawyer is, well, where's the invention? Who invented that genetic trait? I just thought, that just developed through nature. But these patents are being granted, they're being applied for all over the world, and of course, and eventually they come to Australia as well. And they will provide control over those genetic traits to the patent owners, and they will be exercised. There's no question about that.
Thanks, Luigi.